Subscribe to our YouTube channel and press the bell icon to get the latest updates.
Now, over the past few days, we've heard a lot of chatter about how the Supreme Court collegium has recommended names of lawyers and High Court judges so that they can be appointed as Supreme Court judges. But what exactly is a collegium? In this episode of KYC or Know Your Constitution, that's exactly what I'll be telling you about. Now, basically, in the simplest of terms, a Supreme Court collegium is a group of Supreme Court judges who sit together, they come together, discuss to recommend appointment of judges to the Supreme Court and various high courts across the country. Now, this collegium, when it comes to appointment of Supreme Court judges, it comprises of the current Chief Justice of India and 4 senior most judges of the Supreme Court after the CJI. And this group is what is called the collegium, who recommends names for appointments to the Supreme Court. Now, these judges, like I said, officially form a part of the collegium, and if the collegium is considering elevating a High Court judge to the Supreme Court, then the Chief Justice of India also holds consultations with senior Supreme Court judges from that High Court who've been posted in that High Court before or who come from that High Court. When it comes to High Court judges, the High Court collegium comprises of the Chief Justice of the High Court along with 2 senior most judges of the High Court after the Chief Justice, instead of 4 as in case of Supreme Court appointments. Now, this collegium sends its recommendations on appointment of judges to the centre as well as the Supreme Court collegium, but the Supreme Court collegium can clear names only after it receives proposals from the government following the candidate's background checks. So it's the government that's supposed to act on these recommendations first from the High Court collegium. Now, the Supreme Court collegium for appointment of High Court judges has the Chief Justice of India along with 2 senior most judges of the Supreme Court right after the CJI, instead of 4 as in case of Supreme Court appointments again. Once the Supreme Court collegium also approves these names, the files are sent back to the Law Ministry for their notification as judges. But you might be surprised to know that this isn't a system. The collegium system isn't a system that the Constitutional speaks about. In fact, the text of the Constitution does not use the word collegium at all. But this entire practice actually came up and evolved through 4 cases, which we call the 4 judges cases. And these cases basically cropped out of and arose out of the constant struggle between the executive and the judiciary on exactly who of the 2 should have the final say when it comes to appointment of judges to the higher judiciary. Unfortunately, though, this struggle still continues today, and I'll tell you more about this throughout this video. Now, the first of the judges' cases came in 1981, and in this, the final verdict basically said that in the matter of appointment of judges, it is actually the central government which has the final say and not the Chief Justice of India. This conclusion arose out of an interpretation of Article 124 of the Constitution. Now, Article 124 basically talks about the Supreme Court, the establishment of the court, and clause 2 of this provision says that every Supreme Court judge shall be appointed by the President after consultation, just pay attention to this word, after consultation with any judges of the Supreme Court and of the High Courts. So this was on the court's interpretation. The verdict that came, the first judge's case, was on the court's interpretation of the word consultation used in Article 124. But of course, this interpretation was short-lived. It was overruled in 1993 in this second judge's case. Now, in this verdict, basically a 9-judge bench of the Supreme Court ruled that the word consultation actually means concurrence. So what this did essentially was, the judgment gave the judiciary the upper hand in the appointment of judges. This was, of course, considered to be important to ensure the independence of the judiciary, and it was in this judgment that the collegium system was actually born. So in other words, what the Supreme Court essentially ruled in this verdict was that the office of the Chief Justice of India, that is the CJI, would have an upper hand, would have primacy over the government in recommending names of judges to the President for appointments and transfers. But it added that while such a recommendation would be virtually binding on the executive once it comes from the Supreme Court or the High Courts, it can only be made in consultation with the 2 most senior judges of the court, which led to what we now call the collegium system. Now in the second judge's case, the court laid out detailed guidelines as well. There was another important question that was answered in this verdict. So basically the question was that if the collegium actually makes a recommendation, can the president veto it? Now what the court said was, once a recommendation is actually made by the Supreme Court collegium, the government can send it back with express and detailed reasons if it doesn't agree with the recommendation. But if the collegium actually reiterates a recommendation again, then the government is bound to accept it, even if it does not agree with it. Now after this came the third judge's case in 1998, in which basically the court said that when it comes to the Supreme Court appointments as judges of the Supreme Court, the collegium should have the Chief Justice of India along with 4 senior most judges of the Supreme Court. Like I had mentioned before, that's what's being followed right now. But in case of High Court appointments, the Supreme Court collegium would only have the CJI and 2 senior most judges of the apex court. The Supreme Court in the third judge's case also clarified that if the majority of the collegium is against someone's appointment, then that appointment shouldn't be made. But this verdict basically cemented the supremacy of the judiciary in the appointment and transfer of judges. Now the fourth judge's case was actually added to the list relatively recently. It was when the Supreme Court struck down the National Judicial Appointments Commission, that is the NJAC. NJAC was introduced in 2014 through a constitutional amendment and a central law. It basically established a new body, that is the NJAC, for recommending judges to the Supreme Court and the High Courts throughout the country, basically then abolishing the collegium system in a way. There was an amendment, the constitution amendment that I was mentioning. It added Article 124A of the Constitution to establish this new body. This commission was to comprise the Chief Justice of India as a chairperson, and other members in the commission included 2 senior judges of the Supreme Court, the Law and Justice Minister, and 2 eminent people to be selected by a committee comprising the CJI, Prime Minister and the Leader of Opposition. But of course the NJAC was largely seen as another attempt by the government to sort of gain the upper hand in judicial appointments through the composition of the NJAC, as well as the procedure that was laid out for judicial appointments, which would have, like I mentioned, completely erased the collegium system. Of course, in this 4th judge's case, therefore, this was declared unconstitutional by the Supreme Court in October 2015. But in this 4th judge's case, there was a surprising dissenting opinion given by Justice J. Chelameshwar, who lashed out at the secrecy and the lack of transparency in how judges to the highest constitutional courts are actually appointed. He, in fact, he even refused to participate in collegium meetings until there was some record made of what transpired in them. In response and to address such criticisms, the Supreme Court collegium then began putting its resolutions online from October 2017, uploading them on its website. But the resistance against this was felt even then, and it came from within the legal community itself. This included concerns that posting such information online would cause judicial candidates, including senior advocates, sitting judges, and judicial officers, a lot of embarrassment and loss of face if they see rejection of their names by the collegium. They were also putting up, the collegium was also putting up minutes of their meetings, but this has been a little irregular since then. Plus, the Supreme Court had also ordered the centre to frame a new memorandum of procedure. This was in the 4th judge's case, and this memorandum is basically a document which lays down the exact procedure for appointment of judges to the Supreme Court and the High Courts in line with the previous judges' cases. But in the NJAC verdict, this was asked to be revised. However, it has been more than 5 years since, almost 6 years in fact, since that judgment, but as per reports, the memorandum has been stuck because of lack of consensus between the judiciary and the executive. Now a bit about the latest recommendations. These are sort of special and being hailed across, because if these are accepted and the appointments are actually made, India could get its first Chief Justice of India in 2027. But the ball, of course, is now in the government's court, and like I had explained, even if the government sends these recommendations back, it will have to finally notify these recommendations and accept them if the collegium reiterates them again. So we'll have to see what happens going forth. This is Apoorva Mandhani for The Print. Do subscribe to our YouTube channel, and for more such videos, follow us on social media.